Welcome, everyone, to our on-demand training, estate planning for federal employees. On behalf of Serving Those Who Serve, my name is Dan Sight. I'm actually the founder of Serving Those Who Serve. So welcome, whether you're joining us for the first time or you're returning, we're glad you're here. We, Serving Those Who Serve, are a federal benefits education and fiduciary financial planning group with the unique mission to reach, teach, and serve you, the career civilian Fed. I want to begin, as I always do, by saying thank you. Thank you for taking the time to watch today, but also thank you for your service to the government, to the country, to me, to everyone. You do not hear that enough, but you will always hear it here. Now, I know you're watching this on your schedule, and that is exactly why we created this format. We recognize that over the last year, your work environment has changed, and finding time during your workday for professional development, benefits education, things like that has become increasingly challenging. So we made this valuable training available to you whenever and wherever works best, whether it's evening hours, weekend time, you name it, or in segments that fit throughout the day, because you can watch a little bit and then come back. Now, the one thing that is constant for this training is we have Ed Zerndorfer presenting. If you don't know him, Ed is a retired career Fed himself, probably has more certifications than anybody we've ever encountered. He is also hands down the most published author currently writing about federal benefits. You have no doubt encountered his work in Fed Soup, federalnewsradio.com, My Federal Retirement, Federal News Network, and for us, and perhaps most importantly, in the Fed Zone, which you can find at fed-zone.com. Quite simply, no one knows these topics any better. Before we get started, I want to explain a little bit about the model for this training because it may be different than other video trainings you have attended. So today is what we call part one, which means it's general education delivered in this on-demand format. But we also have part two, which is personalized education delivered via Zoom at a time that works for you at your schedule. Why? We've observed over the decades now at Serving Those Who Serve is that people attend multiple webinars, seminars, lunch and learns, trainings, briefings, you name it, and still don't completely understand how their benefits will behave and personally impact them and their families. So part two was created to ensure that you get your specific questions answered, but also to advance to have that deep and personalized understanding without pitches, pressure, or obligation. That part is key. So, because part two education is personalized to you and your family's unique situation, it is offered by appointment only. So throughout today's training, you will see QR codes at various points in the slide, sometimes on the side, sometimes on the bottom. If at any point in time you'd like to schedule a part two, simply use the camera on your cell phone to scan that QR code. This will open a scheduling page where you can select a great date and time that works best for you. Now, if you happen to be viewing this from your cell phone, and I can't imagine why you would when you can view it on anything, but if you are and can't access the camera feature at this moment, simply take a screenshot of one of the slides that has the QR code, then open it up in your Photos app, tap and hold the QR code, and that should open the scheduling page. If you are not a QR code person, that's fine. You can also email us directly at part2@stwserve.com. That will be up on screens throughout the presentation, so you can do that at any time. So here's how this on-demand session will work. Ed will present the comprehensive training content, and throughout presentation, we'll show examples of questions that we typically address in our part two sessions. While you won't be able to ask questions in real time, as you would in a live webinar, you can always email your specific questions to part2@stwserve.com, or again, schedule the part two session where you can address everything unique to that situation. Next, in keeping with our mission, in the interest of full disclosure, Raymond James asked us to provide the following slide. We're happy to do so, but I do want to point out a couple of important things. Number one, Serving Those Who Serve sponsors this educational session to bring Ed to you. Number two, Ed is not here to solicit, never. And today will be purely educational. And lastly, we're not a part of OPM. I'll be back a little bit later to talk about the whole process. Without any further ado, let me tell you a little bit about Ed. He has been helping federal employees have a better understanding of their benefits and make better retirement decisions for over 25 years. Now, I told you he has a ton of certifications. Well, here they come. He is a certified financial planner, a chartered life underwriter, a chartered financial consultant, a certified employee benefits specialist, an enrolled agent, and like all of our advisors here at Serving Those Who Serve, he is a chartered federal employee benefits consultant. and is also a member of the Maryland Society of Accountants, the National Association of Enrolled Agents, the International Society of Certified Employee Benefit Specialists, Financial Planning Association, National Association of Health Underwriters, and the Society of Financial Service Professionals. I told you he writes, boy, howdy does he, every single week for us in the Fed Zone. You can find that at fed-zone.com, as well as for My Federal Retirement. And he is my featured go-to guest on our FedLife podcast. You can find those on YouTube, FedLife. So with that, I will turn it over to Ed. Take it away, sir.
Thanks very much, Dan. Ladies and gentlemen, welcome to this presentation on estate planning for federal employees. Before I actually get started, I want to thank Dan for giving this, and the people that serving as a serve, for once again giving me this opportunity to do another presentation. In this case, estate planning for federal employees. I couldn't do this presentation as well as other presentations that we do, and live webinars. I couldn't do any of this without the full support of Dan and the people at Serving as a Serve. So I want to thank them. And I'd like to welcome you. Before we actually get started, I have to make two statements. The first statement is, Dan went through all my credentials and certifications, things like that. But I have to tell you one thing: I am not an attorney. I do not want to. I want to make sure that I do not ever give out any legal advice when it comes to any laws, especially in this case here, estate planning. If you have particular questions about your particular circumstances when it comes to estate planning, whether you have questions about a will, a trust, beneficiary forms, things like that, you need to talk to an estate attorney in your state to come up with your estate plan. Again, that's who you go to, an attorney who specializes in estate planning. So please, if you have questions in your circumstances, please ask those questions to a licensed estate attorney in your state, in the state that you live in. And if you send questions in to Serving as a Serve about estate planning, please make sure that they're not of a legal nature, because again, people at Serving as a Serve are also not lawyers. They do not give advice. So that's the first thing I'm going to say. The second thing I want to mention is I want to clear up a misunderstanding. Estate planning is not just for the quote-unquote rich people, for the Warren Buffetts. There are many aspects to estate planning. We will see in the course of today's presentation, there are actually two parts to estate planning. One is what I call planning for incapacity. Incapacity. If something happens to you or a member of your family and they cannot make this, or they cannot make decisions regarding in terms of medical decisions, financial decisions, and you have to act, and somebody has to act on their behalf. This is called planning for incapacity. The other part of estate planning is what most people are familiar with. It's called postmortem. What happens when you pass away? What happens to your assets? All the things that you own. How will they be passed on? And that we will also cover. Before we actually get started, I have some important websites up here. I'm going to show you on the screen. The first bullet, www.opm.gov, is where you get all the information about federal retirement, FERS retirement, CSRS retirement. I said FERS retirement benefits. I tend to forget that there's still about a couple 100,000 CSRS and service office employees. So I guess why I didn't include that. But there is information, a lot of information about CSRS retirement benefits, FERS retirement benefits on the OPM website. In particular, if you go to the OPM, it's called the Retirement Manual. The Retirement Manual, all the information about retirement benefits are contained in that manual. And then also there are beneficiary forms. One of the things we're going to be talking about today is, as a federal employee or retiree, have you filled out all your beneficiary forms? There are a number of beneficiary forms that need to be filled out, and they have to be up to date. And we're going to cover that today. And all those forms are on the OPM website. The next bullet, www.fed-zone.com. As Dan mentioned, I write a weekly column for Serving Those Who Serve. It's called the Fed Zone. I write one column a week, every week of the month, every month of the year, on average about 50 to 60 columns on what topics? Employee benefits. I write columns on CSRS. I write columns on FERS. I write columns on Social Security. I've written many columns on the TSP. I've written columns on all the federal employee insurance benefits, including the FEHB and Medicare, dental and vision insurance, life insurance, long-term care insurance. In fact, I've written many columns just on long-term care in general. I've written columns on tax planning for retirement. I'm an accountant. I have an accounting and tax practice, so taxes are very dear to my heart. During this time of year, we're in February now. I'm getting ready for to write columns on how federal retirement benefits are taxed, as well as other benefits are taxed that federal employees have as they prepare their 2025 taxes. And I also write columns on survivor benefits. And yes, I've done a number of columns on estate planning. You name it, I write about it. I've been writing these columns on behalf of Serving Those Who Serve ever since April 2019, almost 7 years. And every column I've written in the Fed Zone has been archived. If you have a particular subject you'd like to read about, like TSP, like tax planning for retirement, like estate planning, anything, all you have to do is go to www.fed-soil.com under the search engine, put your favorite topic, and every column I've written on that particular topic will pop up. I want to emphasize the fact that the way I write my columns is so that you understand them. Nothing high-powered, down to earth, good information. A lot of your questions about your benefits can be answered just by reading my columns. Ladies and gentlemen, let's be very honest with one another. If you're an employee and you have questions about your benefits, and you go to your human resources office or you go to your personal office, first of all, personnel is overwhelmed. They won't have time to answer your questions. They've been cut back. They just don't have the time. Some of the questions you ask them, they cannot answer. They will not answer or should not answer. I'll give you an example. Estate planning. They're not lawyers. They can't answer questions about estate planning. Well, now you can go to the Fed Zone and get that question answered. Get those questions answered just by reading my columns. And if you are a retiree, and we have many retirees who listen to these broadcasts, who attend live webinars, you also have questions about your benefits. Where do you go to? OPM, call OPM. They're not going to answer questions with a phone. They probably won't even answer questions. They don't have time to. Social Security, have questions about your Social Security benefits. Good luck calling Social Security. They've been cut back. You'll probably be put on hold for anywhere from 3 to 6 hours before somebody's going to pick up the phone. And finally, even TSP, it's very difficult to get your questions answered. Call the TSP. You also have a place to get your questions answered just by reading my Fed Zone columns. And finally, the last bullet there, www.stwserv.com. On one of the things on the website, we conduct live webinars. On average, 4 to 5 live webinars each month. They're free. You can attend as many of them as you want. And the more you attend, the more opportunity you're able to ask questions. Because when you attend a live webinar, yes, you can ask questions. In the course of the webinar, there's a segment of time that's dedicated to live questions. So please go to the website and check them out. And also on the website, Serving Those Who Serve, are blogs. Others Serving Those Who Serve representatives write blogs on employee benefits, well written. You could learn a lot by reading those blogs. And finally, there are podcasts out there in which Dan mentioned that he and I each month do a monthly podcast in which we review my recent Fed Zone columns. It's a question and answer session. They run about an hour and a half. You can listen to them at your leisure. There's over 100 podcasts out there on various topics. You can learn a lot just by listening to podcasts. There's a wealth of information out there on the Serving Those website. I want to point out that we are here to help you, educate you. We're not here to sell. We want to answer your questions. We want to help you if you're an employee, to help you get to this now challenging process of being able to retire from federal service. And if you're a retiree, we want to help you as well. So take advantage of it. And with that, let's go ahead and talk about estate planning. Everyone has, just 1 second here. Everyone needs an estate plan. Why does everybody need an estate plan? A comprehensive and up-to-date estate plan maximizes the chances that an individual's wishes with respect to medical and financial affairs will be carried out upon the individual's death or disability. I said a few moments ago, there are two parts to estate planning. One is planning for incapacity. We talk about here an individual is disabled, and what happens when they pass away. That's estate planning post-mortem. Every federal employee has an estate. How so? This is because every federal employee has money saved and invested in banks and credit unions. You have a checking account, savings account at the bank or the credit union. You may have a brokerage account. You invest in stocks, bonds, ETFs, you name it, and you have a brokerage account. You have money with insurance companies. You bought a life insurance policy. A life insurance policy or an annuity that you buy from an insurance company is part of your estate. You own it. If you went out and bought a $500,000 life insurance policy, you are the policy holder. That is part of your estate. Every federal employee contributes each pay date to either the CSRS retirement system or the federal employees retirement system. Every pay date, a portion of your paycheck is being deducted automatically and contributed to either the CSRS Retirement Disability Fund or the FERS Retirement Disability Fund. Almost federal employees contribute to the TSP. That's another part of your estate. The TSP, whether you put money into the traditional TSP or the Roth TSP or both, is part of your estate. Many federal employees own at least one life insurance policy. Let's say they're enrolled in the Federal Employees Group Life Insurance. That's part of your estate. Many federal employees own maybe a private individual life insurance policy they bought from an insurance company, whether it's a term policy or a cash value life insurance policy. They own the policy. That is part of their estate. And let's not forget, many federal employees own at least one piece of real estate. They own a house, a private house, or a condominium. Maybe they have a rental property. Maybe they have a second home, a beach home. This is all part of their estate. But employees must understand that they may not be able to enjoy their accumulated estate due to either incapacity or death. Estate planning is extremely important to ensure that one's estate will be passed on to loved ones at the least possible cost and in the least amount of time. I say that because when you pass away, if you have not made arrangements to pass on property, for example, you don't have a will, you don't have a trust, you didn't name beneficiaries, then what happens? Then you're considered to be intestate. And then the state has to come in, the state that you died in, you're a resident of, and decide who gets what. That can be a time-consuming and expensive process. We're going to find out that even if you have a will to decide who gets what, when you have a will and the assets that you own are put into the will in which you designate who's going to get them, it can be a time-consuming and expensive process. So keep that fact in mind. Estate planning is without doubt a complex and ongoing process. An individual must put together and assemble various available devices, techniques, and strategies to accomplish two main objectives. One, an effective, orderly continuity of one's affairs after one's death, and two, the maximum sheltering of one's property assets against transfer taxes. A comprehensive and up-to-date plan also maximizes the chances that an individual's wishes with respect to medical and financial affairs will be carried out upon the individual's death or disability. That is what estate planning is. Making a plan in advance. Naming the people or organizations you want to receive the things you own after you die, and taking steps now to make carrying out your plan as easy as possible later on. However, good estate planning is much more than that. It should also do the following. It includes instructions for your care and financial affairs if you become incapacitated before you die. Now, this is important for everyone, but I like to say that if you are a single person, maybe you never got married, maybe you got divorced, maybe you're a widow or widower, it's very important that you take care of your affairs, because what's going to happen? You own your assets, you own a certain amount of assets. What's going to happen to those assets when you pass away? Normally, someone's married, it should go to your spouse. Go to your spouse, usually the case, but you don't have a spouse. What happens if you are on, you have to have a decision regarding with respect to medical. You're not in any position to make decisions regarding what medication to take or whether you may need additional surgery, and you're not in a position to make that decision. Who's going to make that decision for you? As I say, if you're a single person, you have to make sure that you appoint someone to make that decision as well. It includes arrangements for disability income insurance to replace your income if you cannot work due to illness or injury. Long-term care insurance to help pay for your care in case of an extended illness or injury. And life insurance to provide for your family at your death. I want to just say something about this disability income insurance. And the best way to explain this is that several years ago, I was doing live seminars for federal employees. I was going around the country. I did various types of seminars. And one seminar I did, it was entitled Financial Planning for New Employees. Financial Planning for New Employees. And part of that live seminar was talking about insurance planning. We talked about the various types of insurance. And I'd asked a question to the attendees. This is a live seminar. And I asked the question, all right, you're a new employee to the federal government. Maybe this is your first job. Have you signed up for any insurance? Everybody would say, oh, yeah. The health insurance. And we heard it's so good here at the federal government. The government pays 72 to 75% of the premiums. You have a choice of plans. We heard it's so good. So we were automatically enrolled and we were so happy. I said, okay, any other insurances? Well, they automatically enrolled us in the Federal Employees Group Life Insurance, vaguely. And it looked good. It's guaranteed issue. There was no underwriting. So we signed up and we took the additional coverages and so on. I said, any other insurances? Well, the federal government doesn't offer auto insurance. Well, you drive a car, but you have to buy auto insurance. We have to buy it from private company. And we also, we rent. We don't own. We had not bought a house yet, so we have renter's insurance. And for those who did buy a house, we have homeowner's insurance. I said, fine. So I said, nobody mentioned something called disability income insurance. I said, what's that? I said, all right, before I tell you what disability income insurance is, let me ask everyone a question. And the question is this. Here, let's say you are in your late 20s, maybe some of your early 30s. What do you think is your most valuable asset? Your most valuable asset, financial asset. What is your most valuable asset? And most people said, oh, the condominium, the house we bought. I said, really? Really? Why do you say that? Oh, think about how real estate has done in this country. Over the past years, real estate on average has gone up over the past 20, on average, last 25, 50 years, on average, 9 to 11% per year. How can you lose? That's our most valuable asset. So at that point, I said, tell me something. Those of you who bought a house or a condominium, do you have a mortgage? Oh yeah, we didn't have sufficient amount of cash to buy that house or condominium with all cash. We had to take out a mortgage. I said, well, suppose you were in an accident or you got very sick and you could not come to work. And you ran out and you used up all your sick leave that you had, accumulated. You're on leave without pay, might go on for months on and leave without pay, maybe a year, maybe longer. You're not getting any income, which means you can't pay your bills. You can't pay your mortgage. You're going to lose that house or condominium. So I said, the most valuable asset you have is your ability to make income, to bring in income via paycheck. So how are you going to protect that? You buy disability income insurance. Now that was for the new employees. Over the past, probably going on 30 years now, I've been doing retirement seminars, now webinars. I would go around the country, and I would always ask the question to the soon-to-be retirees: have you planned for for what happens if you get ill, you can't take care of yourself, and you can't live in your house anymore, and you have to go to a nursing home or maybe assisted living? It's expensive. Are you prepared for that? They say, oh yeah, you have health insurance. Well, you're wrong. Health insurance doesn't pay for long-term care. Long-term care insurance pays if you have to be taken care at home in the form of custodial care. Somebody has to come to your house and help feed you, dress you, assist you for, going up the steps, in and out of the bed. Health insurance doesn't pay for that. Medicare doesn't pay for that. You have to buy separate long-term care insurance. So here's my point. Disability income insurance, long-term insurance is the first step to planning for incapacity, for planning for the fact that you cannot bring in income, that you cannot be in your home anymore. You have to go to a nursing home or assisted living. This is part of estate planning. Provide for the transfer of your business at your retirement, disability, incapacity, or death. If you might own a side business. Maybe you are retired now. You're retired Fed and you open up the business. It's a successful business. Well, what happens if you are the sole proprietor? The business is under you. What happens if you can't work anymore? You can't conduct your affairs? Well, I guess you could buy disability income insurance. It will be very expensive. But if you feel that the business is worth it, you can perhaps sell it. There's a way of selling your business, but you have to plan for that. This is all part of an estate plan. Naming a guardian for your minor children's care and inheritance. If you have minor children, that is children under the age of 18, what's going to happen to them if you get incapacitated or pass away? Provide for family members with special needs without disqualifying them from government benefits. Everyone's heard of SSI, Social Security income. That's for individuals who have severe disabilities. They get these benefits from Social Security. What's going to happen if you have such a child and you get disabled or you pass away and you provided for their care somehow, some way? Would your arrangements have any effect on their SSI benefits? And an estate attorney will be able to answer that question. Provide for loved ones who might be irresponsible with money, who may need protection from creditors or in the event of divorce. God knows every family has some bad apples in it. So something has to be done to protect other family members from that ban in terms of how you're going to be distributing your assets upon your death. minimize taxes, court costs, and unnecessary legal fees, which may include funding assets into a living trust, completing or updating beneficiary designations, or otherwise aligning your assets with your estate plan. A comprehensive and up-to-date plan also maximizes the chances that an individual's wishes with respect to medical and financial affairs will be carried out upon the individual's death or disability. Here are some questions that are related to the need for an estate plan that individuals need to ask themselves. Who will conduct my affairs and pay my bills in case I am incapacitated? Who will act and decide on my behalf regarding medical procedures in case I cannot? Who will decide on my behalf regarding whether I should stay on life support? This is a question that only you can answer. Who's going to make that decision? Who will receive my assets upon my death? What organizations are worthy of my assets? Do you have any favorite charities that you want to transfer your assets to? Not just maybe loved ones. You also give a portion of your estate to charity. How should my assets be transferred upon my death? You want to have a plan that transfers your assets in the least amount of time and cost, because there is a cost involved in many states of transferring your assets. And also, you want to do it in the least amount of time. Have I named the right beneficiaries for my retirement accounts? Is there something I should be doing now in order to minimize any difficulties in transferring my assets and a cost upon my death? These are just a bunch of questions that you have to ask yourself when you are developing your estate plan. All right, so let me just review here. Proper estate planning eliminates certain problems at an individual's death, such as estate planning costs. Yes, it may be expensive. It may be expensive to develop an estate plan, but I'll give you an example. I'm going to give you an example of how the cost can really be exorbitant in terms of coming up with an estate plan. All right, so somebody listening today says, I need an estate plan. So what am I going to do? Zerndorfer said that I have to have my estate plan. I have to go to an estate attorney in my state. Remember, I said that at the beginning. Yes. So I'm gonna talk to friends, get some recommendations. They use an estate attorney and find such an estate attorney. I'll call up the estate attorney, the attorney's office, make an appointment, go in there. They made an appointment. Person makes an appointment. They go into the attorney's office and the attorney says, "Welcome. What can I do for you?" Well, I heard that I don't have an estate plan, but I was listening to this estate planning for federal employees presentation, and I think I need an estate plan. So the attorney says, "Well, do you know what you need to do?" Well, really not really. I'm going to leave it up to you. Can you give me some ideas what I should do as part of my estate plan? So the estate attorney goes through some various scenarios, what should be done, what documents need to be done, and the conversation lasts for about an hour. So the attorney says, "Well, have you decided on anything?" "No, I just like to think about it." Could I come back at another time and then we can finish this up?" The attorney says, "Absolutely, absolutely." So on your way out from the office here, stop by the front desk and you can make an appointment for the next time. Also, don't forget to pick up the invoice for today's visit. He does, the person does, and they make an appointment and they see an invoice for $3,000. $3,000 for what? For the attorney's time. But I had nothing to show for it. He says, "Well, you made an appointment. The attorneys don't work for free." If you go to the attorney's office and say, "This is what I want. I need a will, I need a trust, I need a financial power of attorney, I need a healthcare power of attorney," all the things we're going to talk about today. You know what you want. It'll minimize the cost. You don't go into an attorney's office totally unprepared. You got to know what you want. And I hope in the course of this presentation, you'll have a better idea what you need to do. Proper estate planning eliminates the problems of individual deaths, such as transfer of assets. Like I said earlier, if you own assets only in your name, then upon your death, they got to be transferred somehow some way to somebody else. There has to be some formality here. How is that done? Are they going to be part of your will? Or are you going to put those assets into a trust and have named beneficiaries? Some financial assets that you own, you can name beneficiaries. We talked about life insurance being part of your estate. Anybody who owns a life insurance policy has, names a beneficiary. Retirement accounts, IRAs, TSP, 401k plans, you name a beneficiary. They're going to be transferred according to the beneficiary. Are your beneficiary forms up to date? Care of minors. You have minor children? You need to be very firm here. Who is going to take care of your children, your minor children, upon your death? Because if you don't make arrangements for that, the state's going to get involved. They're going to have a conservator take over, be in charge of your children, and that's going to cost. Proper estate planning addresses lifetime problems such as incapacity. We went through that. Okay. So in order to get this planning going, you have to have a team, in my opinion. You have to have a team. What do I mean by teams? There's a lot of stuff going on here, and you may not know exactly what you need to gather together. So ideally, you'll have some type of financial advisor. That could be an accountant. If you have a financial planner, you have a brokerage account, you have a stockbroker, a certified financial planner, even insurance, the insurance people will know what you need to do, what type of information you need to get together to come up with the estate plan. What are we talking about here? We're talking about what property do you own? I mean, everything. Real estate, personal items, not down to every little thing, but just general. Cars, retirement accounts, insurance policies. How are your assets titled? Are they in your name only? Are they jointly owned? Are they held as tenants in common? Because it's going to make a difference in terms of how those assets will be transferred upon your death, in terms of how they're titled. And the main thing is goals and objectives. What are your goals? When you come up with the estate plan, what are you trying to accomplish here? Well, the real accomplishment is in terms of planning for incapacity is you want to make sure that when you're in a position where you cannot make any decisions regarding your care, your finances, that somebody will be able to step in and make those decisions. And when it comes to postmortem, you want to make sure that upon your death that your assets are transferred to named beneficiaries at the least amount of time and at a minimum of cost. Analyze the data. Pretend death occurred. Pretend incapacity occurred. What's going to happen to your estate and to your family? Okay? All right. So here are 10 important documents to get your affairs in order to come up with. This is called the estate planning checklist. Number 1, last will and testament. Naming a guardian for your minor children. Name a guardian for your pets. Let's not forget your pets. I will tell you that 25 years ago, this never came up. When did the idea of naming a guardian for your pets first happen? 9/11. On the morning of September 11th, 2001, there were a number of individuals who worked in the Twin Towers who left their homes, who left their apartments early on that morning, September 11th, went to work, leaving their dogs, cats, birds, maybe any other pets they own, rabbits, whatever. They were single. went to work, never came home. So when the police went to their homes, apartments, condominiums, whatever, and found these pets, what's the police supposed to do with them? The person had not made any provisions. What happens to their pets? So now pets are part of one's will. Not only who's going to take care of them, but things like who's going to pay the bills for the vet bills, things like that. List all personal property and decide which people, which charities you want to receive each asset. Naming an executor to carry out the terms of your will. A revocable living trust is another type of way of transferring your assets, in which you list all personal property and decide which people, which charities you want to receive each asset. Transferring your personal property into the trust. Someone has to be named as trustee. Now, normally with a revocable living trust, the person who's setting up this trust, they are the trustee. They're in charge. Give you an example. About 12 years ago, my wife and I set up a trust in our name called the Zerndorfer Living Trust, in which she and I are the trustees, we're co-trustees. And all we did was we transferred title to all our assets, including our bank accounts, our brokerage accounts, not our retirement accounts, because they're separate. That's separate because you name a beneficiary for this. With the trust, you're naming beneficiaries. For assets, you could not name beneficiaries. The title to our house goes into the trust. Does this have any tax consequences? No, it does not. We don't, our tax returns, a trust is just a means of, it serves a purpose that upon the death of the trustee, of the trustees, that assets will pass on to beneficiaries without having to go through probate. We're going to talk about probate a little bit later. With a will, your assets that you put into the will go through probate. The probate process can sometimes be time-consuming and costly. With a living trust, what's called a revocable living trust, the assets that you put in there do not have to go through probate. They pass directly to the named beneficiaries. But with this revocable living trust, you have to name what's called a successor trustee to manage the trust after you pass away. So in our case, we named our older son as the successor trustee upon the death of the second spouse. Number 3, beneficiary designations. Many people don't realize that naming beneficiaries for things you can name beneficiaries for is part of estate planning. Okay? There are a number of assets you can name a beneficiary for, and that includes 401k plans. In the case for federal employees, the TSP. Makes no difference, traditional TSP, Roth TSP, you name a beneficiary. IRA accounts, no matter what type of IRA, traditional IRAs, Roth IRAs, you name a beneficiary. Life insurance policies, you name a beneficiary. Pensions, you can name like a CSRS annuity, a FERS annuity, you name a beneficiary not to get the annuity upon your death. Understand that when you retire from federal service, whether you are a CSRS employee or a FERS employee, when you retire from federal service, when you fill out your application for retirement, you have the option of naming what's called survivor annuity. One survivor annuitant, I should say. For most federal employees who are married, it's going to be their spouse. And the spouse, upon the death of the retiree, will get as much as 50% of what the retiree was getting at the time of his or her death. FERS or CSRS or FERS. That's not a beneficiary designation. When it comes to the CSRS and FERS retirement, you name a beneficiary who will receive. Remember, I was talking about earlier that every pay date, a CSRS and FERS employee has a portion of their paycheck being deducted and deposited into CSRS or FERS, Retirement Disability Fund, those contributions came from your salary. That's your contribution to your retirement plan. You get that money back when you are retired. It's part of your monthly annuity. If you want to understand how that's done, please attend one of our monthly understanding taxation of federal retirement benefits. We have a webinar each month, understanding the taxation of federal retirement benefits. Well, once again, those contributions that you put that are deemed deducted from your paycheck, they're done with after-tax dollars. You get them. It's paid back to you as part of your monthly annuity. And if you're giving a survivor annuity, whatever you didn't get back as part of the contributions that you made, your designated survivor annuitant gets it. And then upon the death of the survivor annuitant, any money left over will go to a designated beneficiary. Now, I have a list of the beneficiary forms that federal employees should fill out. I'll show you that later. Okay. I also want to mention that if you have bank accounts, you can name a beneficiary. If your bank account, like you have a bank's checking account, a savings account, a CD at the bank or the credit union, you can name a beneficiary. You can name a beneficiary for brokerage accounts. Like you have a brokerage account at Merrill Lynch or Vanguard or Fidelity. You can put a name of beneficiary. Let's not forget one other part of naming beneficiaries. They need to be update. They have to be up to date. If you named the spouse 30 years ago as the beneficiary of your TSP, and you have since divorced that spouse, you better change that designation. The courts have ruled that if you have a designated beneficiary, whether it's for life insurance or retirement plan, IRA, makes no difference, and you are no longer married to that person, then upon your death, that person will get that money. And you don't want that if you've been divorced. God forbid the person's deceased. You don't want that to go into the estate. No, that's not the way. You got to make sure your beneficiary forms are up to date. Number 4, Advanced Healthcare Directive. Outline your medical care preferences in your living will. Name a healthcare agent to make important medical decisions for you in your medical power of attorney. And we're going to go over those. We're going to go over both the financial power of attorney, which is next, and the health and the medical power of attorney in a little more detail here in a few moments. Insurance policies. Gather copies of your life, health, car, and home insurance documents. Create a list of your financial accounts and institutions, bank accounts, credit cards, mortgages, and mortgages and loans. Proof of identity documents. Gather your proof of identity documents, your Social Security card, birth, marriage, and divorce certificates, prenuptial agreements. 8, titles and property deeds. Gather the titles and deeds for your homes, vehicles, and real estate. Confirm the listed owner is correct. If you establish a trust, retitle your property so the trust is the owner. Here's an important one that people may forget. Digital logins and passwords. Everybody seems to have everything at home on their computer. They have a laptop. Maybe they have a mainframe. If they're still around, you got all this information on your iPhone. Whatever you have, everything seems to have a login as backup. Well, what happens if you're the only one who knows what those login is and login usernames and passwords are? What good is it? What good is it if only you're the one? So you have to have some means of having a list of your passwords, and making sure that whoever is going to be the executor of your estate or the attorney who set up your estate plan knows where those digital logins are contained. What means have you taken care of? We have a program on our computers in which we have a program that lists all our logins, and it's very secure how you get in there. But all the instructions are in a separate file for someone who has to get into to see our logins. Funeral instructions. Create a list of your future funeral preferences. Do you want a burial? Do you want a cremation? What type of service do you want? What passages you want read? Preferred charities or for donations? Whether or not you prefer flowers. I know it sounds ridiculous, but again, the more you plan in advance, the less shock there's going to be when the time comes. Shock to who? Not you. You pass away, right? Well, you don't want your loved ones to be shocked what the cost will be. I will tell you, the cost of dying in this country has got skyrocketed. So you gotta do things way in advance. All right, let's go here. All right. So now let's talk about, in terms of, we're talking about planning for like I said earlier, we're going to break this into two parts: planning for incapacity and planning for postmortem when you pass away. All right, and now we're going to first do planning for incapacity. What every individual needs when it comes to planning for incapacity. The first thing is a financial power of attorney, POA. What is that? A financial power of attorney, POA for short, is a legal document that authorizes someone to handle your financial affairs if you cannot do so due to incapacity or cognitive impairment. You might also create a POA if you are ill or out of the country. Having a POA can be an important step in estate planning. It ensures that someone is ready to reasonably manage your finances if you cannot. Without a financial power of attorney, a court may have to name someone as your conservator or guardian to manage your affairs. What exactly is a financial POA? It is a fiduciary, financial, or legal relationship between you are the principal. You're the one who wants to get this thing up, and the person you designate, the agent, also called the attorney of fact. That means the agent is legally bound to make decisions in your best interest rather than in anyone else's best interest. Generally, the responsibility of a financial POA agent may include managing the following: paying bills, managing real estate and handling personal property transactions, conducting stock, bond, or other security trades, performing banking duties, managing business operations, doing insurance and annuity transactions. Now, I want to share with you a personal experience when it comes to financial power of attorney. And the reason I'm bringing my personal experience, a personal experience I had, is that in my practice, I've seen this too often. As I said earlier, I have an accounting and tax practice, and I have clients who always ask me questions, typically during tax season. What do I do? My spouse passed away. What do I do in terms of how my affairs are going to be conducted in case I get incapacitated? So I'm going to bring up my personal experience here, and that'll lead me into how I responded to one person, one such incident I had a couple of years ago. About over 30 years ago, my father had a stroke, and he was taken to the hospital. He was in intensive care for about 2 weeks. And then after 2 weeks of intensive care, he was not responding to rehabilitation. So the hospital said, "You can't stay here anymore. We had to put him in a nursing home." And after about less than 2 weeks after he was in the nursing home, he passed away. So after he passed away, I said to my mother that we have to do something. We have to do something now to take care of your affairs. I want to just say this up front, that my mother never had anything to do with money. And this, I've seen this too often with families, with married couples, that one spouse takes care of all the financial affairs, the other spouse has nothing to do with it. Well, it's not that my mother didn't want to do it. It's just that my father said, "I'll take care of it." And he did. So now he's no longer around. So I said, "Mom, how do you plan to handle all these accounts you had? You had checking accounts, you got a credit union's account, a whole bunch of accounts." She said, "Well, Ed," "I really had no interest in financial affairs. Your father took care of everything. So I'll tell you what, I'm going to put your name on the account. I'll make you a joint owner." I said, "Mom, you don't want to do that." She said, why not? I said, I trust you. I'm here. You're a financial planner. You're an accountant. Sure, I trust you. I said, Mommy, that's not the problem. That is not the problem. Here's the problem. If you put my name on your accounts. First possible problem is that if I get sued, and God knows in my business you can get sued. Part of a lawsuit, if I don't have enough errors and omission insurance, the creditors and creditors are going to come after my finances. What finances? Everything I own. Everything I own. My house, my banking accounts, my checking accounts. Well, those are your account. That's your money. What's the guy do with me? He says, well, when you put my name on your accounts, you make me a co-owner. That half of that account is fair game for the creditors and creditors. She says, oh, I didn't know that. The other problem is that if I get divorced, thank God it's not happened. Married 46 years, but something can happen. Those things do happen. So, the soon-to-be ex-spouse can say, I want part of your, some of the assets that you own. I want part of them. And my name is attached to that account that you're putting my name on there. No, you can't do that. But they can. So she said, what are we supposed to do then? I said, Mom, it's very simple. We'll put you on, you're going to put me on your account as a POA. She said, what does that mean? It says, you go to the banks, all the banks where you have accounts, all the credit unions, and they had a whole bunch of them, must have been at least 10 different banks and credit unions. And we went to each institution saying, she said, please put my son on there as a POA. And the bank said, we have a form here that has to be filled out. And my mother had to sign it, naming me as the POA. And what does that document at the bank say? Is that in case my mother, for some reason, cannot write out a check because she gets incapacitated, or she's put in a nursing home and she doesn't know what to do. She says and it turned out she did eventually have dementia and Alzheimer's, that I am able to pay her bills. I'm able to make withdrawals from the bank. And if I get sued, if I get divorced, my name is not attached to that account. But then my mother said, well, what happens when I pass away? How will that money go to your account? I said, Mom, there's a solution to that. She said, what? Put it in my will? No. The bank has another form. You can have but in the name of beneficiary. It's called a POD form, payable on death. Payable on death. POD, payable on death, in which upon your death, the POA is null and void. I go into the bank. We filled out this POD form. Here is a death certificate. Please transfer ownership of that bank account in my name. Again, that's the solution to the problem. Now, what about for married couples? Married couples, does it work the same way? Do you have to name your spouse? Let's say you have a joint account. Do you have to name each other as POA? No, because it's a joint account. There's not necessary. But you should name a child who is going to be the POA in case both of you get incapacity. You can name, one child is POA. I recommend you have a backup in case the primary POA is not available for some time, and then you name a POD in the bank account. Everybody still needs a POA. Again, I'll give you an example where what the POA can do. The POA can sign a tax return on behalf of the agent. One last thing about the POA. As I said, we have to go to the bank. It's been my experience over the years that it's rare that a bank or a credit union will honor the attorney's called financial power of attorney. It's extremely rare. The banks, credit unions have their own POA forms that they want to have filled out to allow someone to be appointed as a POA. Okay, so that is the financial power of attorney. What about a medical power of attorney? Let's read what it says here. When life takes an unexpected turn, having a plan in place can make all the difference. A medical power of attorney ensures that someone you trust is legally authorized to make medical decisions for you if you're ever unable to speak for yourself. Whether you're planning ahead or navigating a health diagnosis, a medical POA is a critical part of any estate plan. A medical power of attorney is a legal document that lets you name a person called your healthcare agent or proxy to make medical decisions on your behalf if you become incapacitated. This can include treatment options, surgical decisions, or end-of-life care. Your agent steps in only if you cannot communicate your wishes yourself. Without a medical power of attorney, your loved ones could face confusion or disagreement during already stressful times. Medical providers may be unsure who to consult, and decisions could be delayed. A clearly legally valid medical POA ensures that your healthcare preferences are honored by someone you trust, offering peace of mind to you and your family. What does a medical power of attorney cover? A medical power of attorney covers a wide range of healthcare decisions, including medical treatments and procedures, hospital or care facility admissions, medications and pain management, end-of-life care and life support references, organ donation decisions. Your agent's authority can be broad or limited depending on how you structure the document. Are there any limits to a medical power of attorney? A medical power of attorney only goes into effect when you're unable to make decisions for yourself. Your agent must always act in your best interests within the bounds of your instructions and applicable state laws. It does not allow your agents to make financial decisions or override your stated wishes and other legal documents, like a living will or advanced healthcare directive. A living will states how far you want medical science to go to keep you alive. DNR, do not resuscitate, that type of thing. That's a separate document. Okay? Who should you choose as your healthcare agent? Your healthcare agent should be someone you deeply trust, someone who understands your values, can stay calm under pressure, and will honor your medical preferences. This could be a spouse, an adult child, a close friend, or another family member. It's important to talk openly with them about your wishes before naming them in your medical power of attorney. How do you get a medical power of attorney? Creating a medical power of attorney doesn't have to be complicated. With the right tools, you can complete the process confidently and quickly without needing to hire a lawyer. Well, I don't know about that. This comes out of a estate planning book, and I tend to disagree with that. Everybody seems to worry about what the lawyer is going to charge. But knowing you're going to an estate attorney in your state who's licensed to do this, you're going to get peace of mind. You're not spending money. You're not throwing money away. Knowing it's being done the way it has been in accordance with the laws of the state that you are is reassuring, in my opinion. How do you create a medical power of attorney? Let's go through the steps. Choose your agent. Who are you going to choose? Think carefully about who's best suited for the role. Number two, complete a state-specific medical POA form. You can do this easily through an online platform like Trust and Wills. Review your preferences. Clearly outline your wishes and any limits you are to your agent's authority. Sign your document. Most states require notarizations and witnesses for your POA to be valid. Share copies. Provide your agent, doctor, and loved ones with copies so they know who to turn to if needed. Each state has its own rules about how to make a power of attorney. Some require notarizations or a specific number of witnesses. Be sure to follow your state's guidelines carefully. That's why I'm getting. You go to a state attorney in your state to do this. You don't do this. Don't go online and look for some medical power of attorneys for dummies. Don't do that. Go to an estate attorney. When you create your medical power of attorney through a trust and will, ensure your document you'll be ensured that your document meets your state's legal standards, so you can feel confident it will be honored when it counts. Advanced healthcare directives. That's the third thing. An advanced healthcare directive, also known as a living will or advanced directive, is a legal document that outlines your preferences for medical care in the event that you're unable to make decisions for yourself due to illness or incapacity. It ensures that your healthcare wishes are known and respected by family members, health providers, and legal representatives. There are two main components of an advanced healthcare directive. One is the living will. This part specifies the types of medical treatment a person does or does not want to receive in certain situations. For example, it can include instructions about resuscitation, CPR, mechanical ventilation, tube feeding, dialysis, and other life-sustaining treatments. It provides guidance to healthcare providers about your preferences in scenarios where you are unable to communicate their decisions. And finally, healthcare power of attorney, durable power of attorney for healthcare. This section designates a trusted individual, often referred to as a healthcare proxy agent or surrogate, to make healthcare decisions on your behalf if you are incapacitated. This agent has the authority to speak with doctors, review medical records, and make decisions in line with your values and wishes. And I suggest that you have a primary proxy and you have a backup secondary in case the primary is not available, maybe out of the country, cannot be located, a decision has to be made, you would need to have a backup. Okay, then I have come to some sample questions here. So here they are.
Absolutely. So folks, here's an example of some questions that we've heard through many of our live webinars to kind of get your juices flowing. Again, these are exactly the types of things that you can ask in the part 2. So what I'd like to do is tell you a little bit about the part 2 process that Ed's mentioned a couple of times. First, a little bit of background. So part 2 came about as a result of what we've observed over the decades here at Serving Those Who Serve, that people come into these types of trainings with questions like, what is it and how does it work? Well, then the information gets going. And then those questions frequently morph into, what's mine going to look like? And how is that going to affect me and my family? So that is exactly why we created part 2. So part 2 is what we call personalized education. And the focus is indeed on education. Because of 2 complementary no obligation meetings, while the advisors Serving Those Who Serve, to review your benefits. So today we're learning about estate planning, but we believe no retirement decision exists in a vacuum. All the parts can influence your retirement. So to help you prepare properly, we're going to discuss everything. And to do so, we're going to create a comprehensive report covering all of your retirement benefits. So I like to say the first meeting is data gathering. We're going to ask you to bring some information. Then at that second meeting, we're going to review with you in detail that benefits report. So obviously, we'll do some pension projections, and we'll talk about Social Security, TSP, FEDLI, health insurance, Medicare, survivor benefits. We can answer some estate planning questions. Again, we're not attorneys, but we can talk at a general level. All of these are included in this report. What I'd like to do here, though, is a little compare and contrast between the reports that you're used to from your HR and the one we're going to provide. Those HR reports are great, incredibly accurate. But the one thing that I've noticed is a huge hole in all of the systems is they only show the first year of retirement. You are going to be retired for longer than 1 year. So by contrast, our report goes out much further, actually to age 90. And at the same time, we'll also give you multiple scenarios for different retirement dates as we're projecting out of the longer term what your retirement might look like. In addition, with regards to Social Security, some of those HR reports will give you a summary. And yes, you can always log into ssa.gov to get more information. But our report is going to bring Social Security and your pension together and also show you what future cost of living adjustments might be. And that is really important. So to sum it all up, absolutely, we can have some high-level conversations about estate planning, but also we'll cover FERS, your survivor benefits, FEDLI, health insurance, TSP. There are so many questions right now about TSP, especially with the in-plan Roth conversions, traditional TSP, Roth TSP. Should I do a Roth conversion? What's the best way to get my money out of TSP? Those are all things we can talk about in these meetings. And again, there's no obligation. So, Ed and I encourage people to take advantage of this. We've really never met anybody who didn't learn something from a part 2. And best of all, the meetings are held over Zoom, so you don't even need to go anywhere. So you can schedule them at times that work with your calendar. So again, to schedule a part 2 session, simply scan the QR code, see on one of the slides, or email us at part2@swserve.com, and we'll send you a calendar link, and you can choose a great date and time that works for you. But for now, Ed, back to you, sir.
Thanks very much, Dan. Ladies and gentlemen, we really encourage the Part 2 process. Whether you're an employee or retiree, if you've never taken advantage of the Part 2 process, please do so. As Dan said, I can completely concur. We have never encountered anyone who was disappointed with the Part 2 process. So please, we're here to answer your questions, give you the right direction. Again, please take advantage of it if you've not done so. I'm sure you'll get a lot out of it, and we thank you, Dan, for that information. Okay, so let's move on here and now do the second part of estate planning for post-mortem, planning for death. What every individual needs when it comes to planning for death. Number 1, a will. What is a will? Generally speaking, a will is a legal document that coordinates the distribution of your assets after death and can appoint guardians for minor children. A will is important to have as it allows you to communicate your wishes clearly and precisely. It is advisable to work closely with an attorney to create and update your will. Understand that when there's no will, in the jargon of the legal world, that means you die intestate. Without a will, the state in which you reside, they decide how to distribute your assets to your beneficiaries according to its laws. This is known as dying. This is known as dying intestate, and the resulting settlement process may not produce the results that you would prefer for your survivors. You can prevent this from happening by having documents drafted that you reflect your will. Everybody hears these stories. They didn't want one child or one in-law to get any part of their estate, yet they did not express that as part of their will. Or any document that any legal document, will, trust, and that child, that in-law got by the brother-in-law, son-in-law, daughter-in-law, whatever, ended up getting the assets. Why? Because the person died, did not have a proper will, did not have a thorough will. What is the will consists of? A will generally includes designation of an executor who carries out the provisions of the will, beneficiaries, those who are inheriting assets, instructions for how and when the beneficiaries will receive the assets. This is especially important if you have young children. A minor, someone younger than age 18, actually cannot receive property, money. So you set an age in which they will be able to get those assets. Does it have to be 18? No. If you have let's say a child who is a spendthrift, let's say they're in their teens, 16, 17, and you see they spend money at will, right? At will, excuse the pun here. You could say, well, that child's not going to get any money until they turn 35. Hopefully by the time they reach age 35, they'll be more responsible when it comes to their finances. You designate that as part of the will. Guardians for any minor children. For assets that do not allow for the name of beneficiaries, such as some bank accounts and real estate. Let's take real estate. You cannot name a beneficiary for your house or a rental property or a second home, vacation home. You cannot name a beneficiary. The will is the place that is the place to designate who will get the real estate as well as any related instructions. Some types of assets allow for the naming of beneficiaries, such as IRAs and investment accounts, which enable a direct transfer of the asset without involving the will and has greater authority than the will. These type of assets usually avoid probate and the associated fees, and many avoid certain taxes, helping you maximize what you leave to your beneficiaries. Assets that pass through the will must undergo the probate process. Let's go over that. That anytime you can name a beneficiary, you should. Because when you name a beneficiary to your, for example, your life insurance, your TSB, your IRAs, your bank accounts. I remember I was talking about the POD, payable on death, your brokerage accounts. You have a brokerage account at Merrill Lynch or Morgan Stanley or Raymond James, wherever, in which you invest in. You have a money market account. You bought some open-ended, closed-end funds, ETFs, stocks, individual bonds. It's all through the brokerage. Upon your death, who's going to get those assets? Well, if you designated someone as a TOD or something, it could be more than one person getting it. A TOD, it's called a transfer on death. Then, just like the bank accounts with a POD, these assets will pass to the designated beneficiary without having to go through probate. Now, what is the problem with probate again? What's the problem? Well, the probate process can be costly. The probate process can be timed. It could be delayed. It may take anywhere. I've seen as much as 9 months, as little as maybe as much as 9 months to 2 years to get that estate probated. The probate process can be costly. I'm sure you've heard these commercials on TV. I know I had, where mom is in a nursing home or assisted living, and they have it there. One of their adult children comes in to visit mom, and mom says, "Guess what? I bought a life insurance policy." So the child says, "You did what? A life insurance policy? How at your age? Number one, why do you need a life insurance policy? Number two, how can you afford it?" So the person says, "Well, first of all, the person who sold it to me said that this will pay for your funeral." How so? Well, it was not much of a life insurance policy. It was like $50,000, and most importantly, I didn't have to qualify for it. It's guaranteed issue. And the way it works is that upon my death, the life insurance proceeds are paid out. So the child is paid out to who? Because I think the funeral home gets the money. The funeral homes have made arrangements with various insurance companies to sell these policies to people who are generally over 65. In most cases, they can't be older than 80. And what it is the life insurance policy is guaranteed issue. There's no underwriting. It's at most, I think, $75,000. And they are whole life insurance policies. They build up some cash value. And upon the death of the individual, the proceeds are first paid out to pay for the cost of the funeral. And any money left over will pay for any other costs associated with the funeral. For example, opening and closing the grave, the maintenance of the grave, things like that. That's all they are. Okay. So again, these policies, it's a little bit misleading sometimes. It's called life insurance. Well, it's not. It's really burial insurance. That's what it is. Funeral insurance, if you will. Okay. Whereas with a trust, as I said earlier, we're going to go over trust here in a few moments. If you have a trust, there is no probate process. There's no probate process. Everything, all the assets that are put into the trust pass to the named beneficiaries upon the death of the person who set up the trust. Probate. Probate is a legal process for settling the estate, whether one has a will or not. The probate process varies by state. Many states offer a quicker, less expensive option if the assets subject to probate are below a certain value. For example, if the estate is not worth more than $25,000 or $50,000, it can cost less. I get this question quite a lot. How much is the cost of probate? And I use an average amount in my experience. That depending on the value of the assets that are going to be probated. Now, again, once again, we're talking about assets in which you cannot name a beneficiary. You cannot name a beneficiary. Your house, your personal items, jewelry, tools, cars. The cost of probate can vary anywhere from 5 to 10%, 5 to 10% of the total value of the assets that have to be probated. Okay. Also, another problem. Here's another problem with probate, with a will. It's a public record. Okay. What do I mean a public record? Typically, what happens when one has a will, they have a will written. It's been recorded, signed by all parties involved, and a copy of the will has to be put has to be filed with the probate court in the county in which the person resides, the person who owns the will, a copy of that will. And the reason for that is that when that person dies, the executor notifies the court that the will that the person who owns the will has died. And typically, what has to happen is that anybody who wants to can go down to the probate court and read the will and contest it. Also, the reason that the will is open for public record, for public scrutiny, is that, and I remember this with my mother when she died about 25 years ago, that she resided with us for a while, so I had a copy of her will in the local court. That when I went to the probate court to announce that I was the executor of her will, that they told me I had to take out an advertisement in 4 local papers. 4 local papers that notifying the public that so-and-so, my mother died, creditors, please come forward within the next month. Because if my mother had any liabilities, she had any credit card balances, any type of loan, car loans, whatever type of loans, that those loans has to be paid off. They're paid off. So who's going to know that? Well, these companies, they're going to say to the court, well, this person died, owes us money. Please do not allow assets to be distributed from the estate through, don't complete your probate process, and the court has to give the executive permission to distribute the assets according to the will. But if the person owes money, those liabilities have to be paid off first before anything is going to be distributed. Okay. Also, that will is open for public scrutiny. Invariably, there's going to be some family members who may not be happy what they read in that will. They're going to look over that will and read it and says, gee, I have 3 siblings. I'm one of 4 children. And my father, who passed away, said that nothing is to come to me. He disinherited me. I'm going to challenge this. And that has happened. It doesn't take much to challenge a will. You can come up with a lot of reasons. That doesn't mean you're going to be successful, but you can challenge it. It doesn't take much in terms of you don't even need a lawyer. Okay, so that is some of the downsides of having a will. If I have to say one positive thing, a will, it doesn't cost much to have a will constructed. If I have to give you an average cost of what a will costs, again, depends on mainly the size of the amount of value of your assets that have to be probated. There might be some other complexities associated with your will, but generally speaking, you can have a will written for any, it may cost anywhere from $500 to $1,000. I'd like to share with you another story about the cost of having a will done. I said it earlier. I'm going to repeat something I said. Don't go to will writing for dummies, trying to get a will written by yourself. Have an attorney do it. An attorney's going to charge you that, like I said, anywhere from $500 to $1,000. And here's how my story goes. Must have been about 30 years ago, mid 1990s. I had a client back then who bought her first house. She was single, and real estate, obviously, back in the middle of the 1990s wasn't as expensive as it is now. But, things have gone up. So she bought her first house for about $400,000. A nice house, and when she came to me to have her taxes done, she wanted to know all the things she had to do in getting ready for the settlement. She put a sizable down payment down. The house cost $400,000. So she just wanted to get prepared what had to be done in order for her to go to settlement, and in order to be prepared at settlement and to buy this house. So I gave her a list of costs, the cost of settlement, how much it's going to cost, what are the items you're going to be paying for at settlement, like transfer taxes, and you have to pay the buyer's portion of the real estate commission. That's usually about 3%, and then you pay the sellers, maybe another seller real estate commission, maybe 3%. You can negotiate that with the seller of the house, and various other items. And then I said, you need to hire an attorney, a real estate attorney, to go with you at settlement. She says, well, I hired a real estate attorney when I bought the house. We had he had a contract that he prepared, a Montgomery County, that's where she lived, Montgomery County real estate contract that was accepted by the sellers, and everything was legal. Everything was done legally. So I said, that's great, but you need to have that same attorney represent you at settlement. She said, well, why? Well, among the things that attorney has to do, the attorney has to check the title on the house. What do you mean title? She says, well, you have a title of the house, and that title involves where the house is, the dimensions, and the land, where it starts, where it stops. You don't want to end up buying a house that has a wrong title, or maybe it's out of date, maybe it's not updated. The attorney's going to research that, and most importantly, the attorney is going to be representing you at settlement to make sure all the documents you're going to sign, because you're going to be signing so many documents at settlement, it's going to make your hands sore. Every document is proper. She says, all right, how much is it going to cost me? I said, well, usually a real estate attorney will charge it about $500. And she gives me an amazing look. $500? $500? That's a lot of money. I said, ma'am, how much are you paying for this house? Oh, I paid $400,000. You paid $400,000. Your monthly payments are going to be like $3,000 a month. And you're saying to me that $500 for an attorney to give you peace of mind, knowing that everything you're doing in buying this $400,000 investment is correct? I don't understand you. She says, well, maybe you're right. Maybe I should have peace of mind. I'm going to hire that attorney to represent me at settlement. Well, the same thing with a will. Having peace of mind that your will's being written properly in accordance with the laws of your state. All right. So here are some of the types of inherited assets that are subject to probate. Okay. If you have a retirement account, like the TSP, you have an investment account, okay, with a brokerage. This is non-retirement. Let's suppose you forgot to put your name of beneficiary of your TSP. You have nothing there. Now, the TSP has an order of precedence. That if you have not named a beneficiary, they have an order of precedence. And what is the order of precedence? A spouse, a child, then comes an adult child, then a sibling, maybe a parent. But if you have none of the above, then the TSP is going to pay the proceeds of your TSP into your estate. Your estate. Now, what is that going to mean? It means that your retirement account is going to be put into what is called an irrevocable trust. A trust is a tax-paying entity. A tax-paying entity. And trust tax rates are extremely high. They're the highest. They're much higher than individual tax rates. The result is that when the money is paid out of that irrevocable trust, the trust is going to be taxed. It's going to whittle down. Trust me. You could probably lose half the value of your TSP, your traditional TSP, as a result of those assets being paid out like that. As opposed to the name of beneficiary, in which money goes to the beneficiary, and the beneficiary has to pay tax when they take money out, or in the case of the traditional TSP and the Roth TSP, they do not. Cash accounts that don't allow TOD designation. Now, again, this is the beneficiaries, or POD designations. I can't think of any type of cash account that does not allow a POD designation. If you go to a bank, go to a credit union, which have checking accounts, savings accounts, CDs, they all allow PODs. There are some brokerages, though, in which you can have a money market account, and they're not allowed to have a TOD designation. Real estate, no beneficiary. Personal property, including valuable items. Assets held in tenants in common. We're going to talk about that later, exactly what tenants in commons are. The following are not usually subject to probate. Retirement accounts, TSP, 401k plans, 403b plans, IRAs with named beneficiary. Again, you have to name a beneficiary and it has to be up to date. Trusts. If you have what's called a revocable living trust, you don't, that when the assets, when the trustee passes away, the person who owns the trust, the assets are passed along to the beneficiaries and not being subject to probate. Not subject to probate. Insurance policy proceeds, life insurance policies, life insurance proceeds are not subject to probate and if they go directly to a beneficiary. Investment brokerage or cash accounts with TOD instructions in place. I want to add cash accounts held at banks, credit unions, which you can name a POD. Assets with joint ownership with rights of survivorship. Here you are a married person and you have a joint checking account at your federal credit union. It's in your name. You are the employee or retiree. You're Jim Jones and you're married to Martha Jones. So your account is titled as Jim and Martha Jones, joint tenants with rights of survivorship. And what that means is, if Jim passes away first, then Martha will become the sole owner of the account, and whatever's left in the account is now in Martha's account and her name only. That transfer of ownership, it does not go through probate. It's not a probate process. That's what happens with joint tenants with rights of survivorship. Okay. This means for the assets not usually subject to probate listed on the right, named beneficiaries will likely be able to assume ownership sooner and may save money on court costs and attorney fees. For example, if you have an IRA and you'd like to pass it on to a child, ensure that the IRA's beneficiary designation is made accordingly. The IRA will pass directly to the child without having to go through the often lengthy and costly probate process. So you name a child, and the child, by the way, has to be an adult child. You can't name a minor child as the beneficiary of the IRA. As always, you should discuss your specific situation with your attorney or tax advisor. The rules have changed in terms of IRA, in terms of the passing on your IRA to a non-spouse ever since Secure Act 2.0 was concerned. And this has implications as far as the TSP is concerned. If you name, and you can name an adult child as beneficiary of your TSP, you don't have to name your spouse. When you pass away, you have traditional TSP account, you got a Roth TSP account, and let's say you have 3 beneficiaries, your 3 adult children. Each is going to get one third of your TSP accounts. So when you pass away, your adult children, they have 90 days upon your death to request a distribution of their inherited TSP account. Again, each is getting, suppose it's $300,000. You have $300,000 in your TSP account, so each child's going to get $100,000 in inherited TSP assets. So within 90 days, each of the 3 children have to withdraw their inherited TSP account. In the case of the traditional TSP, they withdraw it and pay tax on it, because that's the traditional TSP. In the case of raw TSP, they do not have to pay tax on what they're withdrawing, but it has to be taken out within 90. It has to be taken out within 90 days. But an adult child, the non-spouse, has another option. Rather than taking the money out, and having to pay tax, in the case of the traditional, the child can request that the TSP directly roll over the inherited portion of their TSP account to what's called an inherited IRA. An inherited IRA, in which the child has up to 10 years from the time they receive the retirement asset, their inherited portion of the TSP. Within 10 years, have that money paid out to them. So in the case of a traditional TSP, and it's going to be rolled over to what's called an inherited traditional IRA. They can take out 10% of their inherited IRA each year for 10 years and pay tax on it. So in that case, the tax liability may not be all that bad. It may have, they're only getting 10%. They've requested 10% each year, 10% each year for 10 years. It has to be withdrawn in full by December 31st, at the end of the 10th year following the death of the TSP owner. In the case of the Roth TSP, they're encouraged to wait till that end of that 10th year, December 31st, to take it all out, because it's coming out tax-free. The longer it stays in that inherited Roth IRA, the more it's going to grow. So this is where some planning comes into play. All right, so what are the legal requirements for a valid will? Okay, first of all, you have to be 18 years old to write one. You have to be of sound mind to write one. Most states require that a will be typewritten or computer generated. There are several options for drawing up a will. One, just take a blank piece of paper, write a few lines of text with a testator's signature at the end. The testator is the one who writes the will, who owns the will, and they write the will. Okay? So they have a signature at the end. And then we have all kinds of websites you can draw up your will. You can go to www.legalzoom.com. Not to be recommended. You can go to software programs like Quicken's Willmaker. As with all wills, it's advisable to have the final document notarized before 2 uninvolved witnesses. The program also includes other estate planning tools such as healthcare directives, a financial directives document, powers of attorney. Cost is usually under $50. Sounds good, right? Don't go for it. Invariably, ladies and gentlemen, something is going to be missing. Have the peace of mind that when you go to a state attorney in your state, that your will or your powers of attorney, financial powers of attorney, medical powers of attorney, advanced healthcare, everything is being done properly. Is everything being done properly? You're not going to get away completely free here. That $50 sounds awfully good, but if something is wrong, something is missing, who's the one that's going to suffer? Your loved ones. They're the ones that are going to suffer. They're going to end up having to pay for the mess. Have an estate attorney draw up the will recommended. The average price will be about $500, but it can be as high as several $1,000s. It depends on the complexity of your estate. Now, trusts, powers of attorney, and healthcare directives and other documents are involved. It can be more expensive. What are the 4 basic types of wills? If you are researching wills, don't stop after you've answered the question, what is a will? Go on to ask yourself what type of a will is best suited for the situation. The 4 main types of wills are simple wills, testamentary trusts, joint wills, and living wills. Let's go over what they all are. What is a simple will? A simple will, sometimes known as a basic will, is the type most people associate with the word will. With a simple will, you can decide who will receive your assets and name a guardian for any minor children. Generic or statutory forms with a simple will format provide an excellent framework. However, you may want to seek legal advice before writing one. This type of will is intended for distributing assets, property, and guardianship for basic estate planning. Testamentary trust will places some assets into a trust for the benefit of beneficiaries and names a trustee to handle it. This type of will, you can put assets in a trust and place court conditions on the inheritance, which may be gradual based on age and other factors that I was talking about. That if you have a spendthrift child, you don't want that child to get any money until they reach a certain age, it's your call. And that's what the testamentary trust will do. This type of will is intended for testators with underage beneficiaries or inheritance recipients. A joint will. What is a joint will? 2 testators sign a joint will to create a shared estate plan. The terms of joint wills, including the executor, beneficiaries, and other provisions, cannot change even after the death of one testator. Because of this inflexibility, joint wills can become problematic for surviving spouses who want to change their estate plans. Now, why would a surviving spouse want to change their estate plan? Maybe to get remarried. They're marrying another someone else who lost their spouse. Both you're the one who lost the spouse and the person you're marrying lost the spouse. Each of you has children. And you decide that you'll get a joint will. Name each other beneficiaries. Well, wait a minute. What about their children? Okay, it's your children. What's going to happen to them? Well, if you put in your will that each is to get the other's assets upon the death, that means the respective children will be cut out. Not a good idea. Not a good idea. A living will. A living will has nothing to do with distributing your property after your death. Instead, it allows you to choose what medical treatments you want to have if you become incapacitated. In a living will, you may also name someone to make decisions on your behalf. This type of will is intended for individuals who want to plan for medical contingencies. Benefits. There's less pressure on the testator's family. That is, the testator is the one who wrote this thing. If they leave it completely open about what to be done in case the testator gets on life support, it's going to put family members in a very difficult position. If the person has to be put on life support, maybe one family member says, let's keep mom alive, okay? And then 2 other children say, no, let's make this dad stay on a feeding tube and see what happens. And then another sibling comes along and says, no, I'm going to, after a while thinks about it, I think we should let the dad die peacefully. It's 2 to 2. What happens? Well, this whole thing would not be a problem had dad made the decision. Under no circumstances do I want to have a feeding tube. It's stated in the living will. That's what's stated. Keep me on liquids. Don't give me solid foods. Keep me hydrated. All this type of stuff in case I'm on life support. Okay. Limitations. The testator must demonstrate a sound mind. In order to write this in will, the testator has to be of sound mind. Okay. Some decisions may be open to interpretation. Okay. It requires a physician's compliance. Considerations and differences. In some states, an advanced healthcare director combines a living will and healthcare power of attorney or medical proxy. You must understand your state's laws or on medical directives to ensure they are fulfilled. All right. So I've come to the point here, Dan. I got questions up here.
Yes, sir. And folks, this is just another example of questions that we've encountered in our live webinars. Kind of get your juices flowing. So you can, if you have questions, you can send those questions to part2@swserve.com, or we talked about how you can schedule a part 2. Happy to help you any way we can. Okay. Before Ed continues, I have something important to share with you. But first, I want to begin by saying thank you. One of the things that we know that we've learned over many, many years now is that many of you found this training because of a friend or colleague telling you about it. And that is really important. Why? It allows us to keep providing these trainings at no cost and allows federal employees to access it whenever they need to. So by sharing this training with others, you're helping us get the word out and you're helping your friends get a better understanding of their benefits. Serving those to serve, we know this, Ed's talked about it. HR and retirement specialists are stretched really, really thin and simply can't do this type of comprehensive education for every employee. So I'm asking for your help. I would like you to think right now of a person who should watch this training, and then please let them know about it. It's easy to do. Simply forward them the link for this training or send them to stwserve.com and they can access all of what we have to offer. We're asking each person to reach just one person. Each one, reach one. So thank you for helping us spread that word about this valuable resource for federal employees. And now, Ed, back to you, sir.
Thanks very much, Dan. All right, so let's continue. And now we talked about the will. Let's talk about a living trust, a revocable living trust. What is a revocable living trust? I say revocable as opposed to irrevocable. Revocable means once the trust is set up, the terms of the trust can be changed. That's not the case with the irrevocable trust. So the revocable living trust, again, is something that you can change in time and that is can be modified for whatever reason. A living trust is a legal arrangement that specifies who manages your assets and who inherits them after you die, all while avoiding probate. When you have a trust, there is no probate process because all your assets are put into are titled, retitled as part of the trust, and they upon your death, those assets will go to the named beneficiaries. A living trust is a legal document that establishes a trust for any assets you wish to transfer to it. Let's explain again exactly what a trust. A trust is nothing more than a mechanism of transferring assets, financial assets, from the person who owns them to named beneficiaries. Named beneficiaries. It's just a means of doing it. Now, is there any taxes associated with this? Well, the answer is no. If the assets, even if they're income producing assets, take for example a bank account. You have a savings account at the bank getting interest. So right now you own this bank account, and you set up a trust. A living trust. And you transfer the trust to various assets you own, including this bank account. And while you're living, are you still getting the interest paid out in the trust? Yeah, it's paid out to you. You're the trustee. And you pay tax on that. You pay tax on the interest you received during the year. It's included as part of your income for the year. What about the trust? Is a trust an entity that pays taxes? Not if there's no income generated. Yes, that That bank account you included as part of the trust. That trust has a federal ID number, but the trust is not receiving any income. It's just there. It's just holding this bank account that's in your name, and the income produced in that trust is still being passed on to you. Upon your death, that bank account is transferred to a named beneficiary with their Social Security number. With an irrevocable trust, remember I talked about having if you didn't name a beneficiary for your TSP account and it's paid out to your estate, the estate is going to receive all your traditional TSP assets, and the trust is going to pay out those assets. Well, the trust is going to have to pay tax on the assets as they're paid out. As you know, when somebody takes, a TSP participant takes money out of their trust for a named beneficiary of a TSP account takes money out of the traditional TSP, they have to pay tax. Well, in this case, the trust is going to pay tax, and trust tax rates are very high, very high. Okay. Once again, the main purpose of doing this, you don't have to go to this with the trust, and so you can avoid this probate process, the time and cost of probate. Under the terms of living trust, which can be irrevocable or revocable, you are the grantor of the trust. You're the one who set it up. It's called the grantor. You set it up. And the person you designate to distribute the trust assets after your death is known as the successor trustee. You are the trustee. You're in charge here. You set this thing up. Okay. And the person who will take over upon your death is going to be your successor trustee. So in our case here, we have my wife and I have a trust, a living trust, it's called the Zerndorfer Family Trust, in which myself and my wife are the joint trustees. Upon the death of the second spouse, our older son is the successor trustee. He's going to be in charge to make sure the assets are distributed to himself and his three siblings, our other three children. Living trust, definition, types, and terms. A living trust is a type of estate planning document that serves two primary functions. First, it specifies who will manage your assets during your lifetime, including if you become incapacitated, as well as after your death. Second, it determines who will inherit your assets after you die and under what circumstances. So back to the Zerndorfer Family Trust. So my wife and I are joint trustees of the Zerndorfer Family Trust. If I get incapacitated or if I pass away, my wife will be the sole trustee of that trust. When she passes away at that point, our older son will be the trustee to make sure that the assets that are in the trust will be passed on to named beneficiaries. You'll frequently see these items associated with living trusts. A grantor. The grantor is the one who creates the trust and transfers assets into it. My wife and I are the grantors of the Zerndorfer Family Trust. The trustee, the person who is responsible for managing the trust assets according to the grantor's instructions. Well, we're one of the same. We are the grantors and trustees. And the beneficiaries, the individuals or entities entitled to receive the trust assets. We have several charitable institutions that we want to give money to when, as part of the trust, as part of our wishes to the trust, the terms of the trust, and after certain percentage of assets will go to our children, a certain percentage will go to our designated charities. Unlike a will, a living trust can take effect immediately, and may help your estate avoid the probate court process. Because you transfer assets in ownership to a trust, there is typically no need for the court to oversee your estate's distribution after you die. Now, why is that? Let's go back to the will. We talked about probate. What does probate mean? Say the probate process. Probate means to prove. Prove what? That the person who died, who had this will, the executor has to make sure making sure to the probate court, the executor is the one who's overseeing the probate process. The number one, when the person wrote this will, they were of sound mind, and make sure that all the assets are being distributed to whoever they're supposed to go to, that all debts have been paid off. That's probably, and after a period of time when it's completed, it has all this process of transferring assets and paying off debts has been completed. Then the executor says, I have proven that every part of the will has been accomplished. And the court will say, okay, fine, now you are free to distribute the assets to the named beneficiaries. There is no such thing when it comes to the trust. No such thing. There's no probate process. It saves money. It saves time. Well, I say it saves money in the sense of the fact that the probate, because of the probate process, the whole idea of distributing the assets and and it can be time consuming. Now, here's the downside now. In terms of the cost of what? Setting up a trust. To set up a trust, it can be pretty hefty. I would, if I had to give you a dollar figure here, how much it costs to set up a trust. Now, again, it depends on how organized you are. In today's world, the costs go up. I would say the average cost of a trust to set up a revocable living trust, you are talking anywhere from a minimum $5,000 to as much as maybe $12,000, depending on the amount of assets that you're putting into the trust. When he set up the Zerndorfer Family Trust, and that was 12 years ago, it cost $3,800. And considering how much work my wife did to get everything organized and list all our assets, I think it may have been too much, because she did all the work. The attorney didn't do that much work, and he said that. He said, "You made my job really easy here." So, again, but we had peace of mind that things are going to be taken care of the way they should, and we've updated several times. We had to put other things into the trust. And there was some additional cost, but nothing compared to had we done it now. The other question I get is, does that mean that if you have a legitimate revocable living trust and everything is signed, that's all you need? You don't need a will? And the answer is no. Most estate attorneys would recommend it, even though you're setting up a revocable living trust, you still need a will. I said, what type of will? It's called a pour-over will. That's P-O-U-R, pour-over will. And what is that for? Well, let's say you set this will up, you set up your trust years ago, like my wife and I. Well, we set up our trust, the Zerndorfer Family Trust. That was in 2014, 12 years ago. We put all the things we wanted that trust to do, including payouts to our grandchildren, our children, our grandchildren, and when the grandchildren will get the money, at what age. Well, at that time, we had 8 grandchildren. We have 16 grandchildren now. Since that trust was set up 12 years ago, we've added 8 grandchildren. So we have a pour-over will. And what the pour-over will says, that in the event that additional grandchildren are born, that this is what each grandchild will get, and at what age. Also, with the pour-over will, suppose we set up your trust, you put in the trust all your assets, but then you added assets. You had a brokerage account at the XYZ brokerage, and you opened up, years later, another brokerage account at the ABC brokerage. Well, the ABC brokerage is not in your trust. The pour-over will say any additional assets that are added after the establishment trust will automatically go into the trust through this pour-over will. That's why I call it a pour-over will. It's pouring over what was not in the original in the original trust. Who needs a living trust? The following individuals are candidates for a living trust. Individuals who cannot sensibly transfer assets by other probate avoidant devices. Those individuals who cannot name beneficiaries, one reason or another. They can't name beneficiaries. I can't think of an example as far as a federal employee, because federal employees have TSP accounts, IRAs, they can name beneficiaries, they have life insurance to name beneficiaries. But there might be somebody out there. The only type of assets they own is real estate, and they have personal items. There's no way you can name a beneficiary. Those with complex debt problems, those individuals who could be sued, easily, doctors, lawyers, yeah, they have malpractice insurance, but depending on the size of they're going to get sued for. They don't have enough malpractice insurance, like they're being sued to commit some errors. God forbid somebody passes away, doctor, lawyer screws up, and they're being sued for, let's say, $10 million. How much E&O insurance they have? Maybe $5 million. Well, if that doctor, that lawyer does not have a trust, all they have is a will, it doesn't take much to challenge what's in that will or to go after the person's assets. So remember I talked about when you have a will and you pass away, the executor has to take an advertisement out in four local newspapers that so-and-so died with a will. Creditors, please come forward. Somebody's going to come, the doctor being sued for, if that doctor passes away, again, the family members are going to find out about that. The person he unfortunately screwed up with for the $5 million and come after the assets that are being transferred in a will. When it comes to a trust, you have to have a lot of money to challenge what's in that trust. A lot of money. So in that sense, with an asset of a trust, if you're in a profession in which you could be sued, I mentioned doctors, lawyers, maybe accountants, financial planners, a trust can be very, very useful. Those with no one to oversee their estates upon their death. You can't, you can't find somebody who will be your executor, personal representative. Okay? So you setting up a trust would be more useful. I say that because who can be the trustee upon your death? You can name a bank. There are bank trust departments that will take care of that. And the benefit of that is if you name an individual as trustee, as a successor trustee, what happens if that person passes away? Are you going to have a successor trustee? Okay. What about when the successor trustee passes away? Well, the bank's going to be around. The trust department's going to be around. Don't have somebody who can be the final trustee. Those who want to quell the ways of spendthrift beneficiaries until they mature and can handle a large inheritance wisely. It's called a spendthrift trust. You set the terms of when that person's going to get the money and under what circumstances. Those who want to give large amounts of money to charities, it's called a charitable trust. Like I mentioned, part of the Zerner for Family Trust is we have some favorite charities we want to give money to upon our death, and that's all part of the trust. Those who want to give to generation after generation, lasting forever, these are called dynasty trusts. Those in second marriages who want to protect children for the first marriage, credit shelter or bypass trusts. There are a number of advantages to using a living trust. They include avoiding probate. We went to that. Providing for your loss of capacity. Your successor trustee will also be able to step in to handle and administer the assets held by the living trust in the event of your incapacity to deal with the assets yourself. So, for example, if you suffer from an accident that leaves you unable to manage the assets in the estate, the terms of your living trust allow your successor trustee to take over without having to apply to the courts for authority to do so. Again, this is not possible if you just have a will. Okay, that's why the trust can be very useful. This is another reason. Controlling the distribution of your property. Like a will, your living trust dictates what happens to your assets after your death. If you have more flexibility in distributing the property to your beneficiaries, and you have more flexibility in distributing the property to your beneficiaries. For example, if one of your beneficiaries is a minor, you can set up a trust within your living trust for that beneficiary until they reach the age majority or an age where you feel they'll be mature enough to handle their inheritance. Keeping your affairs private. The probate process is an open process, which means it's a matter of public record. By keeping your assets in a living trust, you retain privacy for your family after your death. This means people cannot search the public record to see what assets you owned at the time of death and how they were distributed among your beneficiaries. There are also a number of disadvantages to using a living trust. They include transfer of title. While setting up the trust itself isn't particularly complex, any assets you want the trust to hold will need to be properly transferred to the trust. Assets that do not require transfer title, for example, furniture or jewelry, can usually be transferred using a document that assigns ownership rights. But for those assets to which you own the title, such as real estate, a legal change of the ownership of title must be made to the title document itself. This requires extra upfront paperwork as well as ongoing maintenance since assets change over time. When we set up the Zerndorfer Family Trust, the attorney we used said, I need to get a copy of the title to your house, the address, the street address, city, state, and the real estate, in order to apply for a transfer of ownership to the trust. It took about a week, and we got the document. And so now the trust, our Zerndorfer Family Trust, includes the title to our house in the name of the Zerndorfer Family Trust. Costs. The transfer of title process requires additional paperwork and the paperwork of filing fees to register charges with the proper authorities. And if you're dealing with multiple title changes or more complicated assets, it's especially advisable to consult with an experienced estate attorney to transfer title for you. Those fees are all additional costs that are separate from the cost of creating a living trust itself. Now, I want to give you an example where somebody has other real estate. Suppose you live in one state, like I live in Maryland, and you own property in another state. You have a vacation home in North Carolina. You know, North Carolina is a very popular place to be in the summer. You own a vacation home on the beach. Well, does that mean you have to have a separate trust for North Carolina purposes? Because North Carolina has its own rules. No, but what you have to do is you have to consult with your attorney in Maryland who set up your trust because you're a Maryland resident, and your attorney will have to call an attorney in North Carolina, a real estate attorney, to find out what needs to be done in order to have the title to your vacation home, your beach house in North Carolina, titled in the name of your trust here in Maryland. There's going to be extra paperwork and there's going to be extra costs involved in having that done. There's no real tax advantages for setting up a revocable trust. Even though a living trust owns the property transferred, you will continue to be taxed as personally on the income generated by those assets if it's revocable. And while there could be some estate tax and income tax benefits of a living trust after you pass away, depending on how it is drafted, the benefits could also be achieved by a will. I'll give you an example. We've been living in this house, in our house, for close to 37 years. And it's gone up in value. I think we paid $230,000 for it. This was in 1990. And it's probably worth now about, I don't know, $800,000. Okay. So we have a lot of equity in this house. There's no mortgage. So if we were to sell this house tomorrow, we'd have a hefty capital gain. $800,000 minus $200,000 is a $570,000 capital gain. Now, under the tax rules, when you sell your principal residence and you file as married filing jointly, You've been living in this house for at least 2 out of the last 5 years. You've been living here at least 2 out of the last 5 years, ending on the day of sale. You get to exclude from taxes the first $500,000 of capital gain. $500,000 of capital gain. If you file a single, it's $250,000. But here's my point. The trust, the house has the trust is part of the trust. We sell the house before you have to report the sale on your income taxes on Schedule D. It'll show a $570,000 capital gain minus $500,000 for the exclusion, leaving a capital gain of $70,000. That's the same whether the house was in the name of the Zerndorfer family or in our individual names. We filed jointly. Everything is the same. All the bank accounts we have, the interest we get, the brokerage accounts, dividends, capital gains, anything we sell, capital assets, sell stocks or bonds, anything is still under our Social Security numbers, even though it's part of the trust. There's no difference. There's no tax advantages with the trust. Living trust versus will. The following are ways in which wills differ from living trusts. Wills don't come into effect. I said living trust versus will. Wills do not come into effect until after your death, so they cannot be used to manage your assets prior to your death. Wills must go through the public probate process before the distribution of assets covered by the will can be made. Because wills need to go through probate, the will itself becomes a matter of public record. Your will is usually the appropriate place to designate a guardian for any minor children. It's recommended, here we go, that you still have a pour-over, here it is, the pour, P-O-U-R, pour-over will to complement your living trust. A pour-over will exists to transfer any assets that aren't part of your trust to your trust when you die. People often create a pour-over will and a living trust together. A last will can be used in conjunction with a living trust to name guardians for minors and express final wishes not otherwise captured in a living trust. A living trust may be the ideal tool for your estate plan. However, there are distinct pros and cons of using a living trust which warrant careful consideration of whether a living trust is the right estate planning tool for your specific needs. I hate to say this, but if you go to an attorney, most attorneys they're gung ho about these living trusts. They think they're the greatest thing, and they probably are, depending on the size of your estate. But they're not for everybody. Why do the attorneys want them? It's called, how much does it cost to create a living trust? I remember I said anywhere from $5,000 to $12,000. How much does it cost to draw up a simple will? Between $500 and $1,000. That answers the question. All right. Let's talk about titling of property. We mentioned this earlier today, but I want to go through this for the purpose of talking about how property passes to beneficiaries, depending on how it's titled. Sole ownership. When you own something in your own name, sole ownership, one person owns it in their name only, the property will pass according to a will. That asset that's in your name only is included in your will to be passed, to go to a designated beneficiary through the probate process, or a trust. It's part of the trust. Upon your death, that assets will go to a designated beneficiary with no probate process. Okay? A jointly owned property. How does it work? Jointly owned property means with right to survivorship. Right of survivorship. And what that means is 2 or more individuals own a piece of property together. When one of the owner passes away, that person's ownership will go to the other remaining owners without having to go through probate. Example: 4 individuals decided to buy a rental property. Each put down 25% to purchase the rental property. Since they each put down 25%, they are responsible for 25% of the costs involved in this rental property. And they're also the beneficiaries of 25% of the net income. Now, if one of those owners passes away, then that person's interest in the property, the 25%, will be spread over the three remaining owners, but about each gets 8 1/3% of the value of the property was at the time of that person's death. No probate again. Then we have tenants by the entirety, and that's restricted to married couples. It's what is the term that's used is JTWROS. JTWROS. And what that means is joint tenants with rights of survivorship. Let's say we have a married couple, husband, wife. Okay. They're married. They're married, legally married. So they buy a piece of property, okay, a house, let's say $500,000. It makes no difference who put that, where the money came from to buy the property. Let's say the down payment. They bought a property of $100,000, about $500,000, and the husband put down $100,000 from what? His account. He had an account in his name only. Let's say a savings account, only in his name. They're still 50-50 owners. And if the husband were to pass away, then the wife becomes the sole owner of that property. No probate. All that has to be done is the surviving spouse has to go to have the title of the property title in her name only. Then we have community property. There are, I think, 10 states in this country that are what are called community property states. And those states are, I can remember, Louisiana, Texas, New Mexico, Arizona, California, Oregon, state of Washington, and Wisconsin. I think I got them all. 10 states. Now, what exactly is a community property state? A community property state means the following. That if we have a couple who is married in a community property state, whatever each spouse brought into the marriage before they got married, any assets, real estate, cash, brokerage accounts, stays in their name. Even though they're going to use it jointly, it's still their asset. It's their assets. It stays in their name, even though it's going to be used jointly. Ownership reverts to in their name only. And if they were to divorce, those assets that were brought into marriage in each spouse will remain with that spouse. They're not going to be divided up. But any income that was generated while they're married and living in this property state is considered to be half from each spouse. That includes salary, wages earned. It includes investment income. Now, give me an example. My wife had a sister. She passed away about 5-6 years ago. And she was married to a very nice person. They lived in Texas, community property state. They didn't always live there, though. They already didn't live there. So, and any assets that were generated after they moved to Texas, like wages and that was put into savings accounts, things like that, are considered to be community property. That is, each spouse is considered to have half ownership. Well, my sister-in-law died about 6 years ago. So my brother-in-law now has all these assets. But then he remarried. He remarried a woman who also divorced, not from Texas, but, from another state, was not a community property state. And she owned she inherited some real estate. She got married. So that inherited real estate that she has is not going to, now she's living in Texas. They live in Texas, is not going to be considered community property. My brother-in-law has no rights to that because she obtained that property before she got married in Texas. So there are some more complex issues, particularly tax issues, when it comes to community property estates, which I don't have time to go into. Tenancy in common. This is interesting. Remember I was talking about 4 people together buy a rental property? I talked about rights of survivorship. There are 4 equal owners. Well, let's say we have 4 different people who buy real estate, but they're doing it as tenants in common. They're owning the property as tenants in common. Each is putting down 25% to purchase the rental property. Each is going to be responsible for 25% of any costs associated with the property, and of course, each is entitled to 25% of the net rental income. Now, suppose one of those tenants commons decide, I'm out. I'm tired of this. I don't want to be a landlord anymore. I'm getting out of this thing. I want out. So what does that person do? They sell their share to anybody they want to. They don't need approval from the other tenants. They don't need approval. He can do it. He or she can do it on their own without any approval. Whereas with the rights of survivorship, it's the same thing. No. If one of the owners, this is held jointly rights of survivorship, says, I want out, and they want to sell their share, they have to get approval from the other 3 owners to get that new person on board. Tenants in common, not the case. Or suppose one of the tenants in common passes away, and they put in their will that maybe a sibling, or maybe an adult child, will now be the new tenant in common. The other tenants in commons cannot stop that. Maybe they don't like that person. Maybe they feel that person has no experience in real estate. They don't want them. They can't stop it. So there is some danger in this in tenants in common. Okay? Property that passes by operation of law. What does this mean? It means that some assets you own, you can name a beneficiary. Note what I have in italics. A will has no effect on this type of property. Example, the TSP. And they put there on Form TSP-3, they put specific on there, a will is not acceptable as a beneficiary of your TSP account. So even if you said, you didn't see that part there, you just put down my will. Could you name a trust as beneficiary of your TSP? The answer is yes, provided you provide the TSP with a federal ID number, with the name of the trustee. You can name a living trust, yes, but not a will. So what are some more examples of where you can name beneficiaries? I mentioned about CSRS and FERS retirement plans. There is the beneficiary forms. If you're a CSRS or FERS office employee, when you retire, you don't have to wait till you retire. You can do it now. You should fill out Form SF-2808, designation of beneficiary of your CSRS retirement contributions. If you are a FERS employee, you fill out Form SF-3102, designation of beneficiary of your FERS contributions. You can download both forms from www.opm.gov/forms. The forms will be there. The TSP designation for the beneficiary form is TSP-3. IRAs, traditional and Roth. Each IRA custodian will tell you, they say when you open up an IRA account, you fill out a beneficiary form. The beneficiary form will be there. Life insurance, any type of life insurance, cash value, the term insurance, group policies like FAGLI, individual, private owned life insurance policies, name a beneficiary. Here it is with the bank or credit unions. You ask them for a POD. That's a beneficiary, payable on death. Including in the POD form, if you have United States savings bonds, any type of savings bond, I bonds, you can name a beneficiary. Okay, it's called a POD, payable on death. Brokerage accounts, transfer on death, TOD. Forms. Here are the POD forms, okay? And here's this again, okay? Transfer on death accounts, okay? Applicable for states that have adopted the Uniform Transfers on Death Security Registration Act. It applies to brokerage accounts. Yeah, all the states have. No matter what state you live in, no matter which brokerage account you go to, those brokerages are definitely, they have adopted the Uniform Transfers on Death Security Registration Act, and you can ask for a TOD. Now, I used to have a securities license. I no longer do. I'm no longer a stockbroker, but I know when I did have my license, when I open up an account for a client who wanted to invest in stocks or bonds, I would always ask the client, do you want to do a TOD, set up a TOD. And they didn't know what it was. And I had to explain. But my brokerage didn't say to me, well, you got to do that. You don't have to. It's a courtesy. I think it should be mandatory because, again, a TOD like the POD is going to avoid a lot of problems down the line in terms of if you don't have a trust, you're going to have to go through the probate process. That slows things up. Okay. All right. Let's talk about some ways to get your assets to loved ones during your lifetime. This whole business of giving your loved ones assets at your death. Some people may not want to wait that long. I also have to point out, I don't think we're going to have time to get into too much detail. We have in this country what's called an estate tax. It's called the federal estate tax. It is at the time of your death, the value of your estate, which includes everything, is over a certain amount of money. Then your estate has to pay an estate tax. And the estate tax rates are huge. The estate tax, this is the federal estate tax, the starting rate for the estate tax is 46% of the value of your estate. Now, don't hit the panic button here. Because under the Tax Cuts and Jobs Act of 2017, the estate tax exemption was raised to $11 million. $11 million. That's per person. Married couple, $22 million. And it is going up every year. The estate tax exemption was due to expire, the Tax Cuts and Jobs Act of 2017 was due to expire on December 31st, 2025. And Congress last year passed the One Big Beautiful Act, OBBBA, in which Congress decided to retain this large federal estate tax exemption. For this year, in 2026, the estate exemption is $15 million. That's per person. A married couple, it's $30 million. Now, how many people in this country have that type of estate? But here's the problem. There are 12 states and the District of Columbia in this country that have their own estate tax, and the exemptions are much lower. For example, Oregon has an exemption of $1 million. Here in Maryland, there's an exemption of $5 million. You think, well, that's a lot of money. He says, well, in this day and age, how much does it take to have a $5 million estate? What is included in your estate? We're talking about your house, your investments. I mean, take the TSP, and that includes a traditional royalty fee. There's, I think, 200,000 TSP accountants worldwide who have over $1 million alone in their TSP accounts. Think about the value of brokerage accounts. The stock market is all-time high. So it's not so uncommon that the people who live in these states that have much lower estate tax exemptions, they are going to be subject to state estate tax. So what is the solution? Well, one of the solutions is, in order to avoid the estate tax, you can start gifting out your assets while you're living, giving your limit. But there are limits on that too. Okay, so let's read what it says here. When most people think about estate planning, they think about how to transfer wealth and property after their death, probably in a way that doesn't leave a surprise tax bill for their loved ones. But tax-advantaged wealth transfers can be for the living too. With gifting, you can transfer wealth to your loved ones tax-free while you're still around to see them enjoy it. And while gifts aren't subject to income tax, there's no income tax here. When you gift money to someone, that person, the beneficiary, doesn't have to pay income tax. Now, will you have to pay a gift tax? We'll see. Probably not. We'll see. There are ways around that. Okay. Here's what you need to know about this important strategy. Note this. You can make tax-free gifts up to $19,000 per person. $19,000 per person. So, and that's one individual. If you're married, you and your spouse can each give $19,000 to that one person. That's $38,000 per year. These gifts can be made in cash or other assets, securities, closely held business interests, real estate, artworks, collectibles, or any types of property. So long as the total value of your gift does not exceed $19,000 per recipient in 2026, the transfers are entirely gift tax free. Remaining under the $19,000 per person annual threshold also avoids any gift tax filing requirement. If your gifts to any one person total more than $19,000 in a calendar year, you are required to report to the IRS on a United States gift tax return, IRS Form 709. Now, what does this mean? That means that if during this year, let's say you have children or you have grandchildren and you need to help them out one way or another. Let's say one of your children wants to buy a house and has to make a sizable down payment. They don't have the cash to make down payment, and you want to help out your child. Suppose they're buying a house that costs $500,000, and they need to make a 20% down payment in order to avoid PMI, private mortgage insurance. They don't have $100,000 of cash, so you're going to help them out, you and your spouse. So $50,000 can come from each of you. So that's a total of $100,000. But that means you're over, $31,000 over the limit. So that means you're going to have to pay gift tax? The answer is no. No, because the $31,000 excess here will be considered as part of your estate exemption. Remember I said you have an exclusion this year, from your estate per person of $15 million. So what's going to happen is that $31,000 will be subtracted from the estate tax exemption. The gift tax and the extended estate taxes are one of the same. They're under the same rates. By doing that excess $31,000 each of you, you'll take away $31,000 each of you from your $15 million exemption. So that's $62,000 from $30 million. That still leaves $29,950,000, something like that, from your exemption. Okay, and you could do that every year. You can do that every year, as long as you report it on a gift tax return. Because on the United States gift tax return, IRS Form 709, it'll show no gift tax. Okay. You can make as many gifts as you like. The gift and estate tax rules limit the total value of tax gifts you can make to any individual, but not the total number of gifts. You can give up $90,000 per year to as many individuals as you want without filing a gift tax return or paying gift tax. If you prefer to protect or replace conditions on the use of the funds, you can also gift a trust for the benefit of recipients instead of outright to them. Through a trust must be structured in a way to allow for the use of the $19,000 annual gift tax exclusion. Again, you have to work with an estate attorney to do that. So each of us could give to our 16 grandchildren, $19,000 and not have to worry about filing a gift tax return. Okay. And there it is. The married couples can give $38,000. Now it's a limit as far as how much you can transfer in your lifetime without tax. And that is up to your annual exclusion. And then that's what's in the second part there. Okay. Gifting can have an underappreciated benefit. Gifting over a lifetime not only removes the gift from your estate, it also removes any future appreciation in that gift. If you gift $10,000 in stock and appreciates to $15,000 next year, that $5,000 appreciation is not considered to be part of your estate, nor is it considered to be an additional gift. It's out of your estate. Okay? What is considered a gift under gift tax law? According to the IRS, a gift is a transfer of money, property, or other assets, such as a real estate, for which the giver does not receive full consideration. Consideration is a contractual term that means exchange value. Full consideration, as the IRS defines it, is fair market value. The fair market value of property such as real estate is the price that a buyer and seller, both having reasonable knowledge about the property and under no pressure to trade, would agree in the open market. An exchange can be considered a gift and subject to gift tax with the following limited exceptions. Here are the exceptions to this $19,000. If you pay the tuition, let's say your grandchild, grandson or granddaughter wants to go to Harvard this year. They got accepted at Harvard. Now, what's tuition alone? $40,000, and they don't have the money. Well, if you make arrangements after your grandson or granddaughter is accepted at Harvard to pay their tuition, and you write the check out on behalf of your grandson or granddaughter to Harvard, then that $40,000 gift is not a gift. It's not a gift because you made the payment directly. Now, if you give the $40,000 to your grandson, so here, use the money and pay the tuition bill, then that's a gift, which paid you because you paid it directly. Also, the medical expenses paid on behalf of another person. Okay, that person needs. You have a relative. You have a friend who has a very serious medical condition. Their insurance does not cover it. They have to have a major operation that's going to cost a lot of money, and you pay for that major medical expense directly to the hospital, to the doctor, to the clinic, whatever it is. Then that is not considered to be a gift. Once again, if you give the money to that person to pay the medical bill, then that's going to be a gift. Okay, gifts to political organizations, gifts to your spouse. There's no limit as far as how much you can gift to your spouse, but there's no gift tax exclusion. One exception, though. I'm assuming that your spouse is a U.S. citizen. You got to be very careful if you're married to a spouse who's not a U.S. citizen. I'm just reading up about, doing some research about that. If you have a spouse who would say a citizen of a foreign country, Great Britain, France, whatever, and not a U.S. citizen, then you got to be very careful how much you can gift. There's a limitation to how much you can give to your spouse. And of course, there's no limit as how much you can give to qualified charities, okay? All right, and here are the states that have estate taxes. This is the most recent list. I think these are the 12 states in the District of Columbia that have state taxes as well as their exclusion amounts. This is anything above your estate is anything below the value of your estate as of the day of your death this year. If you pass away this year, your estate does not owe any state estate taxes. If you're above those limits, then your state will owe estate taxes. Okay. You can see here's Oregon, $1 million. Massachusetts, $2 million. It used to be $1 million. And many states have actually lowered the rates. There's also what's called inheritance taxes. There are 5 states here who have an inheritance tax. What are inheritance taxes? Inheritance taxes are imposed in the case of assets that are probated, only assets that are given to non-relatives of deceased. All right. As a summary here, let's review what you need to discuss with an estate attorney when you're doing your estate plan. We talked about a lot of things tonight, but here's some things you need to talk about when you meet with your estate attorney. Have a list of your assets and be prepared to answer the question: how are your assets being titled? Who are you going to be your beneficiaries? Who do you want to be named as beneficiaries? Who's going to be your executor? Who's going to be the trustee of your trust? Who's going to be the guardian of your minor children? Talk about the will versus living trust. Does everybody need a living trust? Absolutely not. Does everybody need a will? Yeah, some part of the will. Just a will, or if you have a living trust, you're going to need that pour of will. Who's going to be the trustee named if a trust is divided? Who's going to be? If you're not going to be the trust, you're not going to be the trustee. How is your estate going to be distributed? Do you have any charitable requests? Legal documents that need to be reviewed after the following situation. Let's say you have your estate plan. Does that mean you're done? Absolutely not. Because you might have life events that may necessitate you're having not necessarily to get a new will or a new trust drawn up, but it has to be reviewed. Marriage, divorce. If the value of your estate balloons over time. Think about over the past 10, 15 years. Just think about the stock market, what it has done. Everybody, when the stock market went over what? 10,000, the Dow Jones went at 10,000. I think that was that was like 2000, 2007, something like that, before the downturn in 2008, 2010. Everybody, oh, amazing. And then the book came out about Dow 36,000. Well, we're past that. Dow's almost up to 50,000 now. If your estate size goes up, you move to another state or acquire land in the state. Does that mean you need a new will? Do you need trust? Not necessarily, but you have to have an attorney in that state to review what you have to see if any necessary changes have to be made. You have another child. You adopt a child. You retire. Retiring is a major life event, major change in life. You need to have a major review of your estate when you retire, and you're married when both of you retire. There's a serious illness of you or a family member, changes in tax, property, or probate. You find out you have an irresponsible child, financially irresponsible. Maybe it's time to look at your estate plan. What should every federal employee, federal retiree have as part of their estate plan? A durable financial power of attorney, a healthcare power of attorney and a living will, a will or revocable in trust, a pour-over will, property filled out and up-to-date beneficiary designations, proper titling of assets. This HIPAA organization that names certain individuals who may be informed about individuals' health issues by healthcare providers. Now, a spouse has automatically had that authority, a spouse. But any other family members, you have to give them authority through what's called a HIPAA organization. It's part of your advanced healthcare directive. Part of your advanced healthcare directive will be a HIPAA authorization, allowing family members or friends to have authority in case a decision has been made regarding your health. Here are those beneficiary forms I mentioned earlier. Again, a list of what all beneficiary forms need to be filled out, for federal employees. First one, SF, standard form SF 1152. If you're still an employee, you name a beneficiary. In case you die in federal service, you name someone or someone's to receive the unpaid compensation of a deceased employee. What is that? Unpaid compensation includes if you died in the middle of a pay period. You worked 5 days of a 10-day work period. You died over the weekend in between, whatever. You earned half a paycheck. Who's going to get that? And what about your unused annual leave? When you retire from federal service, you get paid for all unused annual leave and lump sum payment. But when you pass away, you're obviously not going to get paid for that. It's not going to go into your estate. Someone's going to receive that. How so? By filling out that form SF 1152. There's the SF-208 and SF-3102 designation beneficiaries for your CSRS and FERS contributions respectively. Your FEGLI life insurance beneficiary form is SF-2823. And don't forget about your private life insurance policies, individual that you bought from insurance companies. And then lastly, TSB-3, designated beneficiary for TSB. That form, that TSB-3 applies to both your traditional and to your Roth TSB. And if you have a uniform services TSB account, you served in the military, in the reserves, and were active duty, and you got paid, of course, and you put part of your compensation into what's called a uniform service TSB account, you need that TSB-3 should be filled out for that account as well. And that is it. So Dan, let's wrap this up, please.
Absolutely, folks. Working with that as long as I have, I know exactly how you're feeling right now when you're drinking from this fire hose of information. So one of the biggest things to do part 2 is help you process all of it. So I just want to take a quick moment to reiterate the differences between part 1 and part 2. So for example, regarding TSP, part 1 is what are the rules? How much can you put in? How does the match work? Part 2 is how can you maximize your TSP? What's a better strategy for you? Regarding your pension, part 1 is how does it work? What's the eligibility criteria? Part 2, what does your pension look like? And what does it look like if you work a little longer or even a little bit shorter? Regarding Social Security, part 1, what are the rules around when you can draw? Part 2, what is the best strategy for you about when to draw? So on our final screen here, you're going to see the QR code to schedule your part 2 session. Again, just go ahead and scan that or email us at part2@swserve.com. I'll reiterate again, we created this on-demand format because you asked for flexible, accessible training that fits your schedule. And that's what we do here at Serving Those to Serve. We listen to what federal employees need. We do our best to respond. So whether you're just starting to think about retirement or you're getting close to making that decision, we're here to help you understand the benefits and make informed choices. Thanks to Ed for another great training session. And thank you all for taking time to invest in your benefits education. Check out our website, stateofserve.com, for more on-demand trainings. We'll be getting them up little by little. Ed's Fed Zone columns, our FedLife podcasts, and all our other resources. And remember, this training that you're watching right now is available to watch anytime, again, as you want. It's a refresher. There's no limit. And when you're ready for personalized guidance for your situation, we're here for part 2. So thank you for being part of the federal employee community that we serve. Ed, I'll give you the last word.
Thanks, Dan. Thanks, everyone, for joining us for this broadcast. I just wish you all the best in the rest of your federal career, or if you're a retiree, all the best during your retirement. If there are any questions you have, here is the email address to send your questions to Serving Those Who Serve, and send them in at whenever you want to. Someone at Serving Those Who Serve will answer them. If they cannot answer them, they don't know the answer, they send you the question to me. I'll be happy to answer your question. So take advantage of it. And take advantage of all the other stuff, as Dan mentioned. We're here to help you answer your questions. We're here to serve. That's why we're called Serving Those Who Serve. Again, be well, stay safe. And finally, thank you, Dan, for hosting today. I couldn't do this as well as all the other stuff that we do without your full support and the people at Serving Those Who Serve.
Always a pleasure, my friend. Folks, we'll see you at the next thing.